This week on Inside Olympia.
All right.
State Supreme Court Justice Mary Yu is retiring after a dozen years in the High Court. She was a trailblazer as the state's first Asian American, first Latina, and first openly gay justice on the Supreme Court. She reflects this week on her career in an exit interview.
From the TBW studio, it's Inside Olympia with host Austin Jenkins.
Welcome to Inside Olympia. My guest this week has served on Washington's Supreme Court for a dozen years, where she was known not just for her legal acumen, but for also being the state's first Asian American, first Latina, and first openly gay justice. Now she's preparing to retire from the court at the end of the year. Joining me now for an exit interview is State Supreme Court Justice Mary Yu. Welcome to the program. Thanks for being here.
Well, thank you.
And thank you, and congratulations on your upcoming retirement. We're going to talk more about what led you to make this decision. But first, here's some background on Justice Yu. She was first appointed to the court by Governor Jay Inslee in 2014 and then elected to that role that same year, then again in 2016 and in 2022. Previously, Justice Yu served 14 years as a King County Superior Court judge. Prior to that, she was Deputy Chief of Staff to King County Prosecutor Norm Malling. And now, as we head into this interview, you're reflecting on a long career that predated even that time in King County. Takes you back to your roots in Chicago. I want to touch on that as well. But let's start with the here and the now. Why have you decided at this point to step down from the court? Why does the time feel right?
Well, last year I had a little health scare issue that just really, like everyone, right? It just gives you pause and you think. And then, my colleague, Justice Owens, decided that she was going to be the first woman to retire from the court by maxing out, and she did. And then 3 months later passed away. And as I then reflected on the fact that I had been a judge now for 25 years, and Justice Owens really didn't have much of an opportunity to really enjoy retirement, I said to myself, why am I doing this? Why am I continuing? I love this job, but I trust the next generation too. And maybe 25 years is enough, and I really would like to have some time to just simplify my life, enjoy, sip coffee rather than gulp it every morning. And that really just led me to make that decision.
The maximum retirement age for judges in the state is 75?
It is 75.
So in theory, you can work until then, and then they do make you retire.
They do, and I've got a little bit of time if I wanted to do that.
Yes. Your health, may we just ask, how is your health?
My health is excellent, really excellent. Great health care, a couple of surgeries, I'm fine, which is even a more compelling reason why, is I'm feeling good, I have my health, and what greater thing can you have than that? And I thought I've got to take some time now and enjoy it.
Let's go back a little bit to the beginning here. We won't spend a lot of time on this, but your path to the law and to Washington State is interesting. What caught my ear is was that you are the first in your family, I believe, to graduate from college, and that you worked for the Archdiocese of Chicago at one point, and that clearly your faith is important to you. So take us back a little bit in time, the origin story of Justice Mary Yu.
Sure. Well, I grew up on the south side of Chicago to, really a working class immigrant family. And my parents, my father came from China, my mother from Mexico. They never had an opportunity to have an education. And the thing that was most important to them was that their children have an education. So we went to Catholic schools. They really put $5 away a week in order to pay for that tuition. And I have to say, I never met a lawyer. I never knew anyone professionally other than a teacher as I was growing up. And so by the time I was in high school, I didn't think about anything else than maybe just getting a job someplace in our neighborhood.
And fair to say, you weren't, if I read correctly, you weren't even applying yourself to your studies that way.
I was not. I would say survival mode really is the mode on the south side of Chicago in a lower working class family. I mean, it was a good family. And yet at the same time, career ambitions aren't the first thing that you think of or that you're even taught. It was really just getting through. And so by the time I went to high school, there was a teacher in my junior year who said, "Mary, did you ever think of going to college?" And I just said, "Mrs. Finnegan, no, kids like me don't go to college. No, I never thought about going to college." And of course, I knew that my parents could never afford that. And she came to our home, convinced my parents to give me a chance to visit a college, her alma mater. And we went on a visit, and she came back and helped me fill out applications. And before you know it, suddenly I'm being accepted into, at the time was called Rosary College. Today it's Dominican University. And I had no idea what I wanted to do, why I was there, other than I was away from home and this was fun. And so, like every other college kid, I had some fun. But I decided to major in religious studies. And the reason why, when I look back at it, is I wanted to be like the people who I had grown up around. I wanted to be like the good teachers, like the good sisters. But then once I finished college, the question is, well, where do you go now for a job? I went to the Archdiocese, applied for a position, and it was a secretarial position because a young new priest was opening up an office of peace and justice. He was as green as I was about what we were doing. And that begins the story of learning about the church's social teachings. And we didn't do social services. We were asking questions involving systemic injustice or justice. I did that for 10 years. I eventually was appointed the director of that office, did some community organizing work through that, and then suddenly 10 years later, I just thought, you know what, I need some new tools.
Did someone by the name of Barack Obama have any influence on your decision to go to law school?
Well, I must admit that he was among the first of those of us working on the south side of Chicago to go off to law school. And
He was a community
because
organizer in those days.
He was a community
long
organizer.
before he became the president of the United States.
That's right. He was an extraordinary community organizer, and the Catholic Church had provided some funding through the Campaign for Human Development, which was a fund designed to assist communities deal with questions of, again, injustice, and that would have been housing or race. And he was doing faith-based organizing on the South Side, and extraordinary. And then all of a sudden, he goes off to law school. And I think many of us thought, why would he go off to law school? This is where everything is. And yet you can see the wisdom, right, is you need another set of tools to really bring about social change.
So what was it for you that kind of led to the path, aside from the former presidents, perhaps sort of inspiring you a little bit? Where did you make that decision and that leap? Especially because if you had spent 10 years with the Archdiocese and sort of building some seniority, I mean, that was a career underway. It wasn't like you had done a couple of years out of college and then it's time to go to graduate school or law school.
Well, you know, it really, what was important to us was to really try to bring about real change. And for us in Chicago at the time, race was a real problem. And as much as we tried to convince people that racism was a terrible, evil, if not sinful thing, we couldn't really bring about much change. And I thought to myself, you know, there are other tools, and it's called the law. The law can bring about social change. The law creates, frankly, a cause of action if you're discriminated against, if you're not allowed the opportunity, right, to participate in fair housing, to buy that house that you're ready to move into. And that's what was the attraction for me.
So organizing will only get you so far, and then you need other tools in the toolbox.
That's right. Tools that were larger, bigger, wider, more systemic.
So how did that experience and that focus on combating racism and on equal rights sort of inform your thinking as a law student and then in your early years as an attorney?
Well,
And then, of course, I'm curious about how that grounded your thinking as a judge.
yeah, and you know, when I think back, there really is a connection and a line. So I ended up going to the University of Notre Dame in South Bend for law school, which was great because it provided the same social context for studying the law. And it was there that I really got connected to a whole set of individuals and people who cared about the same thing and whose faith really mattered as well. Once I actually got connected to an alum who was working in the King County Prosecutor's office at the time, Mike Duggan was in the civil division, and he just said, hey, why don't you come out here and work for us in the prosecutor's office as an intern for the summer? You'll love it. You're going to love the culture. I decided to go ahead and do that and fell in love with, of course, the most ethical prosecutor that one could ever know, Norm Mailing. Someone who really understood, right, what justice was about. And before I knew it, I graduated, I accepted an offer, I worked for the prosecutor's office, and I remember sitting down with Norm because during those days he interviewed everybody, and he just wanted everybody to know, right, this is not about securing convictions, it's about securing justice, and he was so sincere in it.
And you've said that he was very intentional about recruiting and promoting people of color, people who are gay or lesbian, and others in that office, building a diverse office.
Norm was committed without apology to having that office reflect the community that we served, and was extraordinary in really recruiting. And now you look at the landscape and you see how many judges could trace their roots right back to the prosecutor's office.
But I imagine when you were in law school, you weren't thinking you were going to go work for a prosecutor's office, especially if you had sort of the social justice side of you.
No, that's right. It was a little deviation, not knowing that at the end of the day, the cause for justice was a little bigger than what I had in my mind. And it was because of mentorship that I was able to sustain that vision. But you're right. At Notre Dame, I fell in love with trial practice as a member of the barrister team. That was exciting. That was fun.
Tell us a little bit about your time on the King County Superior Court. What stands out about, I mean, in many ways it seems like a grind. And also, for a lot of people, that's maybe the pinnacle, right? You do that either as a career or you do it for a number of years and then go back into private practice. But for you, what was that time, in a very busy court in King County?
Gosh, Austin, I'd say being on the King County Superior Court was the best time in my life. I loved the lawyers. I loved working with jury pools. I loved what we did every single day, and it was a grind. Every Friday, it was very difficult to sentence 10 to 15 people to prison. It's hard work. And yet I knew it was really important work. We were the ones who were interfacing with the public every single day, and how we did it really mattered. And I learned how to listen. I learned how to learn from the lawyers in front of me. It was incredible. It was great. I loved it.
And I have to ask you about your side gig, if you will, while you were on the court. And I think it also happened on Friday, maybe Friday afternoons, was you started being the judge that would handle adoptions for gay couples. Tell us how that started and how that became a thing that you were known for. And how many did you do in the end?
I think the count might be up to probably 1,300 or so. And it just was accidental. There was an attorney who came to me when I then came to the bench, and she just said, would you be willing to do same-sex adoptions? She said,
Normally, am I correct that the adoptions would be handled by a court commissioner, not even of the judge, because these are fairly pro forma?
That's right.
So asking for the attorney to come to you and say, would you mind doing this, is sort of like an extra ask.
Oh, yeah, it was an extra ask. And the biggest ask is, she said, there's one judge who does it in King County now, but it's hard to get in. Most of the time it's commissioners. There are judges around the state who won't do these, even though there is no prohibition. Would you be willing? And I said, sure, but can you tell me how to do this? I mean, what are we doing? Yeah. And as soon as I recognized that what we're doing is really creating and blessing families under the law in some way, I thought, this just can't be some sort of little thing we squeeze in. We're going to do this at 4 o'clock as soon as we can. When the day is over, we'll move into the adoptions, and we're going to make it really darn special for people.
And how did you do that? Because you could have just run it as sort of an assembly line. It's Friday night. I'd like to get home. How many are we going to get through today?
It
Bang
really,
the gavel.
Exactly, no. It meant slowing it down and really providing the opportunity for people to express their love for each other, what they're doing, why they want to commit themselves to a child, inviting them to invite their families to be there as well. It really was an opportunity to celebrate family. And that's what it became. And it just evolved. And before I knew it, we probably had 3 or 4 a week. And it was wonderful. It was really wonderful. It was a good moment.
I read the Secretary of State's office did a piece about you, and I know that there was an anecdote about a father of one of these couples that was adopting who was not entirely comfortable with this, and I think you had a particular line that you frequently used. Maybe you can bring it back. But what was your line, and do you remember that particular family? In
I
that case?
do remember the family. I can see his face in the jury box.
That's where the family members would
That's
sit.
where the
you turned your courtroom
families-
into sort of this.
That's right. Someone might say a theater in the round in some ways. But it was the closest we could really move people to the setting. And I would always say, the most important thing is to love who your children love. And I think that just struck him is, oh my gosh, what have I been doing? And it was a moment for them to reconcile, for him to recognize, I have to love, right, who my child loves. And this is an opportunity to be made whole, to reconcile, to recognize how important this is.
And then do I remember that there was a second adoption by that couple, and he was back in the courtroom? Pretty happy to be there?
Pretty happy to be there. Pretty happy to recognize my family's growing.
So you also then transitioned from doing adoptions to doing same-sex weddings right around, obviously at the time, that was not allowed, unlike adoptions. That was
Right,
prohibited.
and I did not do them until it was legal.
So that was 2012.
It was 2012.
And do I understand correctly that you performed the first wedding ceremony? Was it sort of at the stroke of midnight?
It was at the stroke of midnight. I hesitate to say I was the first. I think I am the first on record at 12:01, but people were doing this all over the place, so I'm a little
You're one of the.
shy
We'll just
about
say
it.
one of the first.
That's right. And what happened is the law was going to take effect on December 9th, and my bailiff, Takao Yamada, a young mixed-race Japanese fellow, said to me, Judge, my own mother and father could not be married until the law changed because they were an interracial couple. And he said, why should we make anybody wait until the next day? Let's do it at midnight at 12:01. And I looked at him and he said, really, why should people have to wait? Because they've waited long enough. And I said, you know what, you're right. And I said, if the presiding judge and the county executive say yes to opening up the courthouse at midnight, let's do it. We did 13.
13. I was going to ask how many couples wedded that night.
We had 13
Wow.
until 7 in the morning, and then City Hall opened up, and the municipal court continued.
And along the lines of the adoptions, then you continued doing this, right? This became a thing you were known for and willing to do, and people would come to you.
I did, and I loved doing it. Again, what an opportunity to celebrate love. What an opportunity to bring families together.
And this also earned you a portion of your 15 minutes of fame because you appeared on the Jimmy Kimmel Show in 2021 via Zoom, I believe. I don't know if that was because of COVID or because that's how he did it, but let's watch a clip of this. It's very funny.
Perfectly named people who I am pleased to introduce you to tonight. And first we go to Olympia, Washington to meet a state Supreme Court judge and frequent wedding officiant. Hello there, how are you? Thank you for taking the time to join us.
Hi, Jimmy.
So when you do preside over a wedding, do you say, I marry you, marry you?
That's a good line that I might try.
Oh, you haven't? Oh. Overall, would you say this name has been a good thing for you or a nuisance?
No, it's been wonderful. And I just have to say, Jimmy, having this name actually gave me the opportunity to preside over the first same-sex marriage in the state of Washington.
Oh, wow. That's a pretty big deal.
Okay, so I marry you, marry you. Did you actually end up using that line ever?
I didn't. I never really wanted to trivialize what I was doing, of course. And yet, even one of the couples that night who was being interviewed later for a video just said, that she had selected me because of that.
Oh,
that
because-
she said,
oh,
how
really?
cool, she said, to be married by a judge named Mary IU.
That's very funny. Let's talk about the transition then to the Supreme Court, appointed by the governor. What was that process like? I don't know if you put your name in the hat or somebody did that, but how did you make the decision to accept the appointment, and what was the appeal of moving up to the state Supreme Court?
Well, you know, as I mentioned earlier, I loved being on the Superior Court. It was great work. I was good at it. I could almost do it in my sleep. But it was really at the urging of Justice Gonzalez, who was already on the Supreme Court, who really called and said, you know, you really need to consider this.
And he had been a King County Superior Court judge, too, so he had been a colleague of yours.
Exactly. And he now was up at the Supreme Court and said, you know, we need your voice. We need a woman of color up here. We need another trial judge. You really ought to apply. And I gave it really a lot of thought. First of all, I thought, could I really win a statewide race? Because you have to run a statewide election. Do I really want to do that? I've never done appellate work. Why would I want to do that? And yet, I remember telling all of my mentees, you know, when an opportunity comes up, apply. It doesn't mean that you're going to get it, but you should always have a diverse application pool, and that's you. Jump in, at least be considered. So I really went in thinking, I don't think Governor Inslee's going to appoint me. I didn't know him. I didn't know anything about him. I went ahead and applied, and then was very shocked to be sitting across from him being interviewed. Tough interview. He's a lawyer, asks tough questions, and you have to really go through a lot of different bar ratings, and so it's not an easy process, but I thought if I'm going to apply, I'm going to go for it.
So when you made that move, what was the biggest surprise, the biggest shock, the biggest difference? I mean, as you noted, it's not the trial courts anymore, it's the highest appellate level in the state. But what tell us a little bit about that transition.
Yeah, you know, I didn't know that it's an adversarial process. And probably the first few times I sat at the table at case conference, I'm being polite, because as a trial judge, you spend a lot of time listening, being polite and thoughtful. And it wasn't until maybe a few meetings in that Justice Gordon MacLeod said, you know, Mary, this is an adversarial process. You have to fight for how you think the law ought to be. That's what people want. And then Justice Johnson came to me and said, you know, when we differ, we are at our best. And I started to rethink, what do you do here? You don't have a lot of niceties. You got to get in there and fight and duke it out and say, this is why I think the law should be this way or that way, or bring my experience to the table and say, this is not going to work at the trial court, whatever it might be. And it's then that I realized what this job was about. So to me, that was the biggest surprise, is that it really is 9 different views, 9 people duking it out, and it is adversarial. You just have to be ready to defend a view that you might have.
And just to take that one step further, the adversarial nature of it is that you are trying to convince your colleagues to see things your way so that you can build a majority opinion.
Absolutely right.
And in terms of the opportunity to write the majority opinions, and you obviously take turns, you can write dissents, you can write a majority opinion that sort of supports what others have written but has a different flavor to it. But what was, when you were writing the majority opinion, what was that process like, or how did you approach that?
Well, when you're writing an opinion for the court, the first thing is really you're reflecting the court's decision. And I really, because I came from the trial court, I really try very hard to try to have unanimous decisions. And that means sometimes writing very narrowly so that you really are not losing people because of what might be said, you know, in a paragraph that you don't really need, or you're willing to insert a footnote. But I really believe that that's most helpful. Not everybody shares that view, and I understand that. But I think that it's important to try to write as narrow as possible and to move the law incrementally when you can, to try to keep a majority. So that, to me, is what I keep in mind the most. Doesn't always work, but nevertheless, it's been something I've been committed to.
Concurrent opinion was the term I was thinking of.
Yeah, I like those too.
Okay. Just before we go to break, I do want to ask you about the makeup of the court. We have had most, if not all, of the justices were appointed, sitting justices today, were appointed to the court and then ran and were elected. We've had Democratic governors for so long that obviously that's been the choice of Democratic governors, you know, Gregoire, Inslee, for certain. Previously we have had Justice Sanders, who had a very libertarian bent, Justice Jim Johnson, who was viewed as a more conservative member of the court. Do you have any concern that this court, while it's diverse, it lacks sort of political diversity, sort of on that left to right spectrum.
I think I would disagree with maybe the inference or implication under that, and that is, regardless of where we might be politically, personally, I can tell you that we are all over the place in that room, and that we are a very richly divided court on a lot of subject areas. We don't have a lot of unanimous decisions. It's 5-4, it's 6-3. It's fought hard because of the different views. So the image maybe of the court is, gosh, this is a court that likes each other and plays together, it seems, or all think alike, and it's group thinking. And I can tell you, it is far from that. It is richly divided, and I think that's a good thing. So despite the differences, I don't know.
Just to press that one step further, though, and I hear what you're saying, nonetheless, it seems like there's that the court doesn't necessarily today have the ideological diversity that maybe it once previously did. It has gained diversity in other ways, absolutely, but has lost perhaps some. And again, you can refute the premise. I'm giving you that opportunity. But I could see conservatives in this state, Republicans in this state, those who knew the court before might say, geez, this court, it's all people who emanated from appointments by Democratic governors. They may be diverse, but ideologically, maybe not so much.
And I'd say they're not reading the opinions. I really would say they are not reading the opinions. They're not reading the majority, the concurrence, the dissents. I think we are very different in our views on a host of issues and how we approach a variety of topics, but we're not ideologues, and that might be what some people are missing. And that, frankly, is a good thing. I think we have some thoughtful people who might be conservative in certain areas of the law and others who are not. But I would say we don't have ideologues, but we have diversity of viewpoints.
A related question, and then we are going to go to break. We are speaking before Election Day, and so we don't yet know the outcome of the Pennsylvania retention races for 3 Supreme Court justices who do, in that state, they actually do run as party affiliated with a party, but and then they have this kind of interesting process of every 10 years, you're up for a retention vote, unopposed on the ballot. But that's become a multi-million-dollar national level battle because Pennsylvania is arguably the most important swing state, or one of the most important swing states in the country. Last year, we saw, I think, $100 million spent on a single Wisconsin Supreme Court race. What do you think of, how are you observing this sort of nationalization and politicization of state Supreme Court races, at least in key swing states?
Yeah, it's a concern. Whenever there really is partisan politics and that kind of money involved in any judicial race, it ought to be a concern, right? Because you don't know really who's influencing what vote or how it's even being utilized in some way. I just have to say, I'm grateful we are in a nonpartisan state. I'm grateful that we do have open elections. I'm grateful that I ran statewide and not by district. I am grateful that I feel like I work for all of the people in the state of Washington. Very different. It's not to say that we're not going to be threatened by outside money coming into the state, but so far, I think we're okay.
Okay, let's take a brief break. When we return, we'll continue our outgoing exit interview with retiring state Supreme Court Justice Mary Yu. Back right after this.
Here in the International District of Seattle sits the historic Panama Hotel. This truly is one of the most historical places in our entire state. We are very lucky to have this segment of history of the Japanese internment. This tells a big part of the story.
Welcome back to Inside Olympia. Joining me once again is Washington State Supreme Court Justice Mary Yu. I want to ask you a bigger picture question and then talk about some specific cases. I do think people wonder how justices of the Supreme Court approach their work. And so I'm interested in how, when you're deciding a case, how you bring your sort of legal philosophy and your sort of personal view of the world to bear, and then this interpretation of the law, and sort of to use a term we've been using, marry those things into an opinion that you can defend?
Yeah, it's almost, you know, as you were asking the question, what came to mind was sort of like a salad bowl in many ways, right? There are a lot of different things that you might be looking at. For me, the record is really important to understand what really happened in this case. What did the judge really say in terms of their rulings? Because obviously sometimes we're looking at legal questions, and I want to understand that in my own way. I don't want summaries and I don't want briefs. I really want to see, what did the judge really say? So going to the record is important. A just result is important, and I have to ask myself and my staff all of the time, what's the right thing here? And does our law allow us to get to that place? And if not, then how do we at least begin to build towards justice in some way? So if it's a line of law that we can only move incrementally in order to be more just, is this the case that allows us to do it? Another example might be a public records case that comes, and this is involving a cell phone, right? Question becomes, is anything on there a public record? How do we get there? What's the record? We need to move the law to have everyone understand that it doesn't matter where the record lives, right? It's a public record if it's a public official doing some work on a phone.
So updating the law to account for the fact technology changes.
That's right. For technology changes, for reality, for the context. So for me, that's how I might approach it, is what's the result here? And is it right? Is it fair? Is it just? And what's the law say?
We sometimes hear the term, and it's not always in a positive light, activist judges. We might hear this more in the context of the U.S. Supreme Court. But when you talk about moving the line towards something that you think is a little more just, what is the balance point there in terms of operating within the law, activism versus also sort of that underlying, the underlying law or whatever the Constitution originally said?
Yeah, the line might be, how do you really see the relevance of the law today? And it matters to me, the context, right? Today's problems were not yesterday's problems. Today's problems need to be looked at in light of precedent, in light of the wisdom and intelligence that we have. So I don't see the law as sort of fixed at a point in time. I think it's dynamic, I think it's static, and I think it has to respond to current circumstances.
You were on the court for a dozen years. There's no way we can get to all of the decisions you authored, but let's talk about a couple. One is something I covered, so I'm interested in your perspective on this. It was the case involving Tara Simmons, who is now a state legislator, but at the time was trying to sit for the state bar exam to become an attorney, having gone through Seattle University Law School, and but had a felony record, and reached a point where there was a question about whether she'd be allowed to sit for the bar exam and become a licensed attorney to practice in this state. The court heard her case, decided in her favor, but you were front and center there. Tell us a little bit about that. Take us inside.
Yeah, that's my favorite case when I think about the opinions that I've written over the years. And it's because of who Tara Simmons was. Here's somebody who, had admitted in the hearing her prior history, admitted what she had done, but she was an individual who had taken the time also to rehabilitate, to really confront the issues that contributed to her criminal history. And the question really for the court was, is your criminal history a categorical bar to practicing law? And we answered, no, it is not. And opened up the door for the fact that, rehabilitation is real and possible. Redemption is possible. There is hope for everybody who's either made a mistake or maybe not a mistake, but intentionally committed a terrible act, but can be rehabilitated and should be able to rejoin society in its fullest. And the question for some was, gosh, an attorney really has a special trust relationship. And again, I think one can be restored, and Tara Simmons proved that. And it was right for us to be able to say she is morally fit. She has the character to practice law. Here's the criteria. We're not changing the criteria. We are simply saying she has met it. And so we remove the categorical bar. Does somebody still have to prove they are fit? Absolutely. So we didn't lower anything.
So at the time, prior to this decision, there was a categorical bar. If you've got a felony on your record, you're not going to be a member of the bar.
The presumption was you are not going to be a member of the bar.
So it had to go to the Supreme Court. You all looked at this and said, we're going to take that kind of automatic disqualifier away and instead have a set of points that will be reviewed to decide if somebody should sit for the bar.
Right. And what really made the difference here is to simply say, what has the person done since that felony act, right? What have they done to demonstrate their character, their fitness, and their ability to practice law? And here was a person who had demonstrated that she could.
Another case, State v. Sum, had to do with considering race as a factor in search and seizure cases?
Yeah, and this is a case where the question really was, what should a judge consider when evaluating the totality of circumstances when somebody is stopped? And in the state of Washington, our law says, you know, you're seized when you no longer feel free to leave. And that can be a variety of things that might contribute to you not feeling free to leave. And at the time, we had just undergone really a lot of social unrest, a lot of enlightenment, if you will, about the experience of black men when they're stopped by police officers. And we simply said, you know what? In looking at the totality of circumstances, a judge should look at a person's race, because a young black man might really, at a different point than anybody else, say, this is when I am seized. And that might be at the moment of contact with the law enforcement officer, out of fear of what might happen otherwise. And we just said, we're not determining the outcome, but we're saying you need to consider race in the totality of circumstances in asking that question.
So in practice at the trial court level, how might that be applied?
I think it would be applied is when a judge is asked whether or not there was a seizure at that moment, a judge has to look at the person's race and ask themselves, is at what point? And you'll have somebody testify, at the moment this law enforcement officer stopped me, I felt I was not free to leave because I was afraid that if I did, I might be shot. You're just looking at it and considering one more factor.
And if the court found that race was a factor, then where would it go from there?
Then you might say, from there, depending on what the facts might be, is that's when the person was seized. Once you were seized, then right?
Then that's the point at which other rights kick in.
That's right.
What we are, you noted the sort of environment in which this decision was, from the court was made, which was, I presume, was it around in the aftermath of post George Floyd's murder?
Post.
Yeah. We're obviously now living through a period of history where there's tremendous pushback on diversity and equity initiatives, on the idea of placing race sort of first and foremost, or making that a key factor or consideration. And so I'm curious about sort of how you're reflecting on this time we're in this country right now around race and equity issues.
Yeah, you know, I think everybody would have anticipated there's going to be pushback. But, you know, I have to just say, is I believe our court is really committed to justice. And we're going to keep looking at issues that merit our review, no matter what. We're going to consider a variety of factors, and that could be race, it could be gender, it could be one's disabilities. I think we have an obligation to see what there is to see, regardless of political pressures from anywhere else.
We had the Chief Justice on the program not so long ago, and she talked about that work. I mean, up to and including when the opportunity arises to review and rethink prior decisions. Can you speak a little bit more to just the work that this current court is doing to try to advance these issues that you said you've been working on for your entire career around race and equity?
Yeah, I think, you know, our court's going to continue to look at a variety of, and I don't want to say cases, because you look backwards only if you're really looking at changing precedents. Otherwise, you really are continuing to develop the common law. But if we do have to reverse a case because it was incorrect and harmful, I am very proud to be part of a court that's not afraid to do that, to be able to reject perhaps the case that said, right, Asians couldn't practice law at one point. So I think that's what we're called to do.
I want to ask you about another decision that this is just so interesting. So when you were, as I understand it, on the King County Superior Court, you sentenced a woman named Cheryl Liddell to life in prison under Washington's 3 strikes, you're out law. I presume you didn't have much option at that point because she had gotten her 3rd strike. But then, and I believe this would have been a 2nd-degree robbery, would have been the 3rd strike.
That's right.
And then there was a process of revisiting that as a strike. Did we in fact remove it?
I believe that it was no longer a qualifying offense. The legislature changed that,
right.
and said somebody ought to then have the ability to be resentenced.
So there was the opportunity then for those whose 3rd strike had been 2nd-degree robbery, and this was, prosecutors were supporting this change, to then, as you say, be resentenced. And her case then came before you again, but this time you were as a Supreme Court justice.
Well, no, the only thing
Oh, I
is
got
that
it wrong.
it never,
Oh, it didn't come to you.
it didn't come back before the court. It went back to the trial court for a resentencing
Right.
hearing. And it was my successor judge, Judge Sam Chung, who then was the judge. And at that point, I was asked to write a letter in support
Got
of
it.
her resentencing. And I did. And I just said, as a trial judge, I had to impose this sentence.
You remembered this case?
I remembered the case, and let me tell you something else about it. I remembered the case because it's very difficult for any trial judge to impose a life sentence without the possibility of release. You have to do it, it's the law. Some people just really deserve it. And others, you hold it heavy in your heart. But I met Cheryl Liddell again when I went back to Purdy to speak.
the women's prison, yeah.
That's right, to speak at the women's prison for a TED Talk. And I got up and talked about hope and redemption and people leaving and they needed to prepare themselves. I sit down and Cheryl Liddell stands in front of me and says, "Do you remember me?" And I said, "Of course I remember you." And that started the relationship. She then shared that she had found a new life in prison, that she was fine with staying because she had a purpose now, and that was to help young women leave. And I just have to admit that it came full circle, that we continued the relationship, and that I had the opportunity actually to support her sentencing that then was for time served. Because I really felt as a trial judge I had no choice but to impose this sentence, and that she did merit a second chance. And we still are in touch today.
You are. And she's
Full circle.
She's doing well?
She's doing well.
As you think about sort of that relationship, I don't know if it fits into the category of mentorship, but you have over your career mentored a lot of people, a lot of young women, and made a real point of that. Can you speak about the role of mentorship, about helping to bring other people into the law who might not otherwise have seen this as an opportunity, and sort of how you've prioritized that?
Yeah, thank you for that question. It matters a lot to me that people who are preparing to become lawyers fit in from the very beginning. And studies over the years have shown that, frankly, women of color, particularly black women, leave the profession sooner than everybody else. And part of the studies indicated it's because they never felt included, that they weren't given the same opportunities as others to succeed. But it also boiled down to many of them didn't have mentors, somebody who was actually encouraging them to stay in the practice. And so I had the privilege of working with James Williams of Perkins Coie to lead the Leadership Institute, which was a program that was designed to help lawyers discover their real gifts and real talents, and to not only be good, but to be great. And it was an intent to try to attract people who were traditionally not included in those leadership opportunities. So mentoring, yeah, has been a big deal because it takes very little to just offer some encouragement. Today at Seattle University, the question might not even be related to women of color, but first-generation lawyers who often will say to themselves, "I don't quite fit, maybe I should leave," right? And the trick is to provide some mentorship and encourage them to stay because we need them.
And I should note you're teaching at Seattle U.
I am.
And so that's another way, obviously, that you're giving back to the next generation. You co-chaired the Washington Leadership Institute, or have co-chaired it for 17 years.
For 17.
And I understand it's just launched a 5-part podcast celebrating its 20th anniversary and spotlighting diverse legal leaders in the state. I do want to ask you about, kind of going back to the work of the Supreme Court outside of deciding cases. There was a statewide youth diversion report that came out this year. I understand you had some role in sort of supervising this, and it has to do with the idea of when a kid or a juvenile gets involved with the justice system, the opportunity to divert away from being criminally prosecuted to some sort of reparations community sort of kind of program that then keeps this off their record, presuming that they stay out of trouble going forward. What did that report? Who led that report, and what was the takeaway?
Sure. Well, the report came out of a Minority and Justice Commission subcommittee. We have a Youth Justice Committee.
And so I should also, I'm sorry, back up and note that the Supreme Court has a now permanent Minority and Justice Commission. This particular report sort of fell into that umbrella.
It did. And this commission, their sole purpose is to really identify issues within the system that contribute to racism and to find ways where we can undo that in our own system of justice.
And where there's disproportionality.
Disproportionality, practices that should be changed. And we do a lot of that through studies and reports. And so this was one opportunity to highlight some alternatives to incarceration. And it was, again, our Youth Justice Committee. I'm proud to say it was led by Katie Hurley and Judge Keenan and great staff, Mr. Frank Thomas, who's on the staff at AOC, who works with the minority.
That's the Administrative Office of the Courts.
That's right. And he really was the one who supervised it directly, ensured that there were opportunities for many of our law students to also contribute to the report. I think it's a solid piece of study, and hopefully somebody's going to take it up.
And was the takeaway? Do I remember correctly in my reading of this that when you look at who is being given this opportunity, that there is a disproportionality in terms of I guess in this case, juvenile defendants of color who are not getting the opportunity as often as their white counterparts?
That's right.
So what is the solution to that problem? How do you start to get to, if there is that disproportionality? And obviously, if you can keep a juvenile offense off your record, that can have implications for your entire life going forward.
Right, and we can continue to try to point to flaws in the system that create the situation, but when you start looking at, okay, what are the answers? Okay, let's consciously try to provide diversion opportunities. It's one way to consciously say, this is an overrepresented population, and let's direct some energy here. Unlike, let's go back and try to, again, fix the problem, which we do and should do, but nevertheless, consciously provide more opportunities for these young people.
I'll just note that there, and if any of these strike you and you want to make a comment, please do, that there has also been work looking at jury diversity. That was a survey in 2023. There's real gaps there. There was a report back in 2020, 2021 on girls of color in detention and racial disproportionality for juvenile detention rates for girls. The court has looked at legal financial obligations or penalties, the fines that are due, in addition to whatever prison or jail time you might serve, and how people, oftentimes that debt stays with people and makes it hard to kind of get back to being a contributing member of society.
Yeah, what I'm most proud of is that all of these reports led to some policy changes by the legislature. They took up the topic. There were changes made that actually made a difference. And we think that's the biggest contributor, frankly, is to provide some data, provide the background for others to make some policy choices.
You'd mentioned that in Chicago, working for the Archdiocese, you felt like it was very hard to close the gap or to address systemic racism, to be able to really see change. Now, reflecting on your career, your time in the judiciary, your time as a pre-lawyer working in community organizing, what's your view of that arc of justice?
You know, probably the long view is maybe marrying the experiences to say, you know, change doesn't happen without individuals, without the heart being in the right place, but also connected to the law. I used to see these as two separate avenues, and now I can really see that it takes both. It takes really approaching people and seeking personal conversion in many ways, but also systemic change, institutional change that will then mirror justice by our practices. And I think it takes both.
Couple last questions. I do want to ask you about, I asked earlier about the politicization of judicial races. There's a lot in the news these days about threats against judges. We've heard that in particular with the federal judges of late, but I know that Supreme Court justices and local judges are not exempt from this. We're in a period of tremendous political polarization, lack of trust in institutions, and people feeling much more brazen, I think, about directly threatening people in roles like yours. In fact, we saw a family member of a federal judge in New Jersey was murdered. What are your thoughts, observations? Have you experienced direct threats?
You know, I've been lucky enough to never have really had a direct threat against my life at all. I'm very, very lucky, but I would have to say, it saddens me deeply that my colleagues, whether they're state court judges or federal judges, actually have to be concerned about their safety. I'm hoping post-retirement that I'll be able to write a few articles about it, express a few opinions that really I shouldn't at this point. But I think that we all have an obligation to cultivate a kinder, better society, but certainly one that defends our judges who are just trying to do the right thing.
It also seems like our court system sort of broadly is under a real stress test right now. Obviously, there's countless lawsuits being filed by Democratic-led states against the Trump administration, and serious questions of the law being asked and will be answered in the coming months. At the same time, trust, as I mentioned, is low. How are you thinking about sort of the pressure courts are under and the lack of trust in institutions, including the courts?
It's a really hard question. I don't know. I don't know the answer other than that we continue, all of us continue, right, making hard decisions. We're the most transparent branch of government that there is. We actually articulate the reasons for decisions. And so I honestly, just continuing the dialogue, shining a good light on what judges are trying to do. District court judges across the nation are really upholding the rule of law like we have never seen before.
And in terms of advice to fellow judges, up-and-coming judges about judicial independence, impartiality, the importance of trust, do you have any advice?
The advice is do it well, do it in a transparent fashion, and be proud of what we do. We are a branch that is the rule of law.
Well, tell us a little bit about your post-retirement plans. Is this real retirement? What do you plan to do? And
it's real retirement in the sense that I don't intend to be working for compensation at all. I really want to take some time and go back to my own roots of maybe volunteering. There's a lot of community work that needs to be done. I'd love to tutor children to improve their reading skills. I'd like to work with immigrant populations. And so the first thing will be just taking some time and slowing down.
You have been described as strong but private, judicious but tender. Not my words. Do you agree, and what do you want your legacy to be?
Oh my gosh. Maybe the legacy is simply she believed in the next generation. I really believe passing the torch on. I believe in the goodness of others. And hopefully that's what people will understand, is I really believe in the goodness of other people.
And what about for your successor? What advice do you have to succeed on the Washington State Supreme Court?
Hang in there. Hang in there, work hard, and trust that your colleagues care as much about the law as you do.
What would you say to your colleagues who you had some adversarial moments with?
Well, I had the opportunity to express this the other day, is that I love you dearly, and what we do is really important. And I felt always that it was a privilege to be at this table.
Okay. Justice Mary Yu, thank you for coming in. Thanks for doing this interview. Congratulations on your retirement. Enjoy it. I think you've earned it, and I appreciate the time.
Thank you so much, Austin. Thank you.
Good to talk with you. Thank you for watching Inside Olympia. We'll see you again next week.